friends, back in the studio on this series on estate planning. So I want to deal with some of the myths that there are about estate plans and wills in general. And I think one of the biggest ones is that if I have a will, then there's no need to go down to the courthouse. And we just follow the instructions on the will and that's that. That's not how it works. A will is a roadmap left by the person, the loved one who has passed on, of how they want their assets divided, but it is not an effective legal document until it has been filed with the court, whatever probate court that is, and then the application proceeds, and then there is a approval by the applicant to be the executor of the estate, which is usually how it works. And that executor then gets letters testamentary authorizing them to open a bank account, to do an inventory, to make a report to the court, and then make a distribution of the assets in accordance with the wishes of the loved one who has passed on. So having a will does not avoid probate. What it does is it leaves a roadmap for the division of assets and the payment of all final debts. So that way, when there's a need for instruction by the person you probably leaned on and relied on the most, you have it. Anyway, you cannot avoid the probate process by having a will. It is part of the probate process, and it's, in fact, it is the keystone in that is the application to probate a will and then follow the wishes of the declarant of that will, the person, the loved one who has passed on, to their ultimate end, to their completion. So if that helps dispel the concept that a will doesn't require you to go to court, that's what it's meant to do. The only document in estate planning that'll avoid the courthouse is a trust, and I'll talk more about that later. And the other one would be, as I touched on before, those powers of attorney, which avoid the whole guardianship process because it makes somebody in charge of medical and financial decisions for a loved one. But again, that's only when they're alive, right? So the only way to avoid the entirety of the probate is to have a trust, and that declaration of trust makes the estate distribution, what have you, completely privatized, outside the scope of the court. But it's really not, it's not an instrument that your average citizen needs unless there's a great deal of assets that need to be managed and grown for the future benefit of minor children, or maybe there's other reasons to keep it together, lots of land, etc. The trust declaration is just something that most people simply do not need. I mean, unless your assets are in the 500,000 plus, it's just not something that most people need. And avoiding probate, the cost of avoiding probate and the cost of a trust declaration essentially negate each other, because it's depending on the size of the estate. You know, we all want our loved ones to live as long as possible and basically outlive their money, or live to the very end of their money. And then, you know, that way there's nothing to distribute and absolutely nothing for families to fight over. That doesn't always happen, but short of that, unless the assets are just massive, a trust declaration is not always necessary, simply for the notion that you just want to avoid the probate process. It's not that difficult a process. It's not that complicated a process. And unless the assets merit it, it's the cost benefit of having the trust declaration really doesn't make sense, simply to avoid the probate process. I'm going to talk more about the myths of probate here in this next segment. Please like, subscribe, and share, and always know that I welcome, I'm very receptive to any comments, and I'll either answer them in a subsequent video or with a direct message back to you. Thank you so much. And without further ado, I'm going to talk about other myths in the estate planning process.